This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Todd Lutsky does join us now from the law firm of Cushing & Dolan. The segment here is Ask Todd, and this is your chance to ask Todd your estate planning questions live on air right now. Phone lines are open at 888-205-2263. Get calling early and often if you want to ask Todd your estate planning questions, because we do have limited space on those phone lines. Again, 888-205-2263 is the number. One more time, that is 888-205-2263, and this is your opportunity to ask Todd your estate planning questions. Mr. Lutsky, how are you doing today?
I am never better. How are you doing?
I'm good. I was pretty intrigued by that story over the weekend about the duck that robbed the bank.
I must have missed that story.
Yeah, he quacked the safe.
Well, that's true.
Yeah, pretty impressive stuff. Todd, I want to talk to you about beneficiary designations on IRAs. And specifically, let me ask you this, I guess. Is there a conflict or a question in terms of potentially naming a trust as a beneficiary of an IRA,
right,
in order to help manage estate taxes in the future, with trying to navigate the 10-year withdrawal rule that you have when that trust is named a beneficiary, and perhaps ending up with your bennies paying more in taxes than they would otherwise,
like
in
income
doing so.
taxes.
Correct.
Yeah,
more
sure.
income taxes than estate taxes that they would have paid.
I think you got a great question there, because there's a lot of balls in the air, right? So one would be, we haven't, when you're dealing
I had
with
someone ask me this the other day, and I said, I don't know, but I have an estate planning attorney I'm going to ask. So this is, a real question that I got from someone.
Real life stuff. That's what we do. Real life stuff. And IRAs are complicated, right? Because they do have, as you were alluding to, Chuck, they have both the income tax component built into it, and, as many people forget, an estate tax component built into it. Even like with Roths, they think, oh, well, their Roths are income tax free. Yeah, but they're estate taxable.
Sure.
And so you got to remember that they have those two components built in it. Now, first and foremost, when we're talking about naming a trust a beneficiary, or in general dealing with an IRA in your estate plan, let's start. Primary beneficiary, if you're married, should probably always be, I don't want to say always, there's never an always, but mostly be surviving spouse.
Why wouldn't you do the trust in that case? Because that's specifically kind of what this is looking at.
Yeah, so generally you want it to be the surviving spouse because of that RMD, the required minimum distribution rules, right? Spouses are one of the few special beneficiaries under the Secure Act, when the Secure Act changed. So, example, if I name my spouse the designated beneficiary, and my spouse, let's say when I die, is 75, my spouse gets to take it out over her life expectancy. If you look at a table, her life expectancy could be 12, 13 years, 14 years. So that's a nice payout. Better than if I name my children the beneficiary, it's going to come out over 10 years. Most of the time, unless the child is a minor or disabled. So mostly this is going to come out over 10 years. So there's a 10-year rule, not a lifetime rule. The old rule used to be, it would come out over the kid's life expectancy, but no more. So now it comes out over 10 years. So that's why the primary beneficiary is usually the spouse. Now, that said, what if I'm the surviving spouse? Now who should the primary beneficiary be? Well, I need to look to my revocable trust, let's say, if that's what I've done. Well, if my trust, which holds a bunch of my assets, says I leave everything equally to my kids, but held in trust for their life, divorce-proof, creditor-protected, generation-skipping, tax planning, all built in, well, maybe I don't want my $1 million IRA going out to my kids. So I probably wouldn't name the kids. I would name the trust as the beneficiary, if I'm now the surviving spouse or single. And that way it gets into the trust, sheltering it from all of those negative creditors, or creditor issues, and even generation skipping tax problems. But to your point, Chuck, not causing a problem with the 10-year payout. So no conflict with the 10-year payout. It's still going to come out over 10 years. No better, but no worse.
Talking with Todd Lutsky from Cushing and Dolan. If you've got a question for Todd, this is your chance to ask it. 888-205-2263 is the number to call. We do still have a little bit of room on the phone lines, so call 888-205-2263 to ask Todd your estate planning questions. That number again is 888-205-2263. We're going to take a quick break here, but when we come back, it is going to be right to your questions with Todd. That phone number one more time is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Still a little bit of room on the phone lines if you've got a question for Todd Lutsky. 888-205-2263 is the number. Again, it is 888-205-2263. Let's go now to Bob in Charlestown. Bob, what's your question for Todd?
Good morning. My question concerns the income tax aspects of the 401k when it goes through the testamentary trust. So,
Yes.
So if there's no surviving spouse and the 401k is the beneficiary is the estate,
Got it.
and under the will it passes into the testamentary trust.
Uh-huh.
So now I presume the trust will now own the 401k, and since the beneficiaries are the children and not a surviving spouse, is the trust required to pay out that money to the kids in the 10-year time frame as if it had never gone to the trust?
So we have to sort of clarify your question, because the question you're answering is one that I likely would never suggest. Okay, so when I talk about naming the estate the beneficiary, that's when you are married, you do that. Okay, so if you're married, and so we got husband and wife, right? And they both have, and you're saying 401k, but let's say they've retired and they've rolled their 401k into an IRA. It's the same deal, right? And so now we're married and I've got this IRA sitting there and I'm over 73 years of age or 73, okay? Unless the IRA is small enough that a 5-year payout doesn't matter. But let's say it's large enough that I don't want a 5-year payout, so I got to make sure I'm 73 years of age or older. That's the first requirement. And that makes it payable over the ghost life expectancy of the participant. So that's huge. So now I don't have a negative income tax consequences. Then I die. Well, then the estate, it would flow into a testamentary trust for the benefit of who? My spouse, right? First and foremost. If my spouse has already died, well, then I usually get a call from the surviving spouse saying, I lost my spouse. What do I do? We update their estate plan because they're now single after all, and we need to make some changes to their plan. And one of those changes would be, okay, well, we now need to rethink your designated beneficiary because you're single. So as a single person, I probably would go back to the idea of what Chuck and I were talking about a minute ago, and that is I would probably not name the estate the beneficiary. Well, why? Because I don't have a spouse, right? The whole point of naming the estate the beneficiary is so that I can provide for my spouse just like I could if I named her the beneficiary, but at the same time, instead of naming her as the beneficiary, I am allowing her to not only enjoy it, but if she gets sick, it's immediately protected from the nursing home for her. To me, that's the big reason for doing this. Yeah, there's some estate tax benefits as well, but to me, that's a really big reason, for doing this. So if I don't have that spouse, well, I'm not so worried about it, right? Because it's mine, and if I get sick, it's outside the trust. It's subject to the nursing home. If I die, I want it to go probably to my trust for the benefit of my kids, divorce-proof, creditor protection, and whatever other kind of controls I want to put over it to them. Now, that said, so my answer, so I think your point is that your hypothetical I would never do. So if I was single, I wouldn't be naming my estate the beneficiary, in which the testamentary trust would be the children. Now, having said that, I guess the question could be, what if we've done this, my wife's alive, it flows into this testamentary trust, then my wife dies? Well, that's different. Well, that could happen. So Bob, I just wanted to help everybody understand that difference and how this could not generally be set up that way, but it could end up that it's now for the kids. The required minimum distributions will come out and hit the trust over the 10-year rule that we talked about. So now the kids are the beneficiaries. If this trust says pay it out to the kids, divide it equally and pay it out to the kids, well, then as the money comes into the trust, it comes out to the kids. The kids pick it up on their income tax return, and that's the end of it. If it's completely a payout, then the whole entire IRA could technically just flow through and go right to the kids. And then they can take it out over 10 years taxed at their rate. If it's held in divorce-proof creditor protection language, like hold it in trust for the benefit of the kids and, let them have income and principal in the trustee's sole discretion, which I like, well, then you have to make a decision. And you're absolutely right about this, Bob, that if that money comes out, the minimum distribution, you reach in, take it out, put it in the trust, that's a taxable event to the trust. If the trust then distributes out that income to the beneficiary, well, then they can carry an income distribution deduction and have it taxed at the kid's level. If the kid's going through a divorce and we don't want the money to come out, well, then you know what? We're going to have to pay the tax at the trust level. So yes, you could have that issue, but it's kind of optional. So great question, Bob. Lots going on in that question. Sorry it was such a long-winded answer. But it's important because it really does deal with what this guide is talking about this month, right? This guide is saying, how do you name your IRA the beneficiary? Not only how do you do it, when do you do it? Why do you do it, right? And same thing with life insurance. You can make the life insurance the beneficiary, and age is not an issue. But with an IRA, as we saw, the age should be at least the required beginning date of 73. That's all laid out in the guide. It explains the testamentary trust, how it's connected with these assets, and will then help you do estate tax planning. It will protect it from the nursing home without a 5-year waiting period, and all without causing adverse income tax consequences, which I hope I just explained in this to Bob in this call. 866-848-5699 is the guide, folks, or legalexchangeshow.com. This guide explains all of those things and how they work together. Call and get it, 866-848-5699 or legalexchangeshow.com.
Todd, just kind of looking at that situation that we outlined earlier, any other considerations just for, how someone goes about making the decision for naming beneficiaries on retirement accounts, given the complexities that we went through?
Yeah, I'd say a couple of things. One, the size of the IRA, right? So if someone's trying to do planning and they say, well, I got $100,000 in my IRA. Well, one, maybe I don't care about trying to protect that from the nursing home. Maybe it's small enough that I'll just leave my spouse the beneficiary and I don't need to go to probate for that. So that could be. Or the size could be, $100, $200, even $300,000. If I got to pay that out over 5 years, well, that's not a huge income tax hit, right? I'm not taking out a ton of money. If I've got $300,000 over 5 years, that's not going to blow me into a higher income tax bracket. So maybe I don't need to wait until I'm 73. I can just set that up right away. So those are some options. And I think if you're not doing nursing home planning, certainly we're never going to be doing a testamentary trust if we're not doing nursing home planning. But I still might name the estate. I still might name the trust the beneficiary on a revocable trust. I would say you would do that primarily only if the way you're leaving the assets to the kids is to protect it from divorces and generation skipping tax purposes. Otherwise, probably just name the kids.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.